Good morning. Welcome to Probate Weekly. I'm Bill Gross at Bill Gross Probate on social media or billgrossprobate.com. And we host this live on Zoom every Thursday morning, 9 a.m. Pacific and 12 noon Eastern time. And then we also broadcast on various social medias, LinkedIn, Facebook, and such. We have a Facebook group, Probate Weekly, put it there as well. And our format is normally an interview format. Really lucky to have a great guest today. And the idea is that you guys, whether you be real estate agents or vendors or attorneys, you have a chance to really talk to different thought leaders in the business. And today we really have a great guest who I've had the chance to talk to and has really just, I think, an interesting angle on the business I wanted to share with you. Just some housekeeping before we get started. The program is probateweekly.com, which is if you want to sign up for it, just go to probateweekly.com, put in your email address, and you'll be registered. You'll get the link for the Zoom calls. And if you want to scroll down, you can see past episodes or sign up for the audio versions or past episodes on YouTube. And we continue the conversation on our Facebook group, Probate Weekly. You do have to go there and register. And if you go there and put in your email address, you'll get different attachments and things we'll talk about in the meetings. Love to have you participate there. We're launching a new program, YouTube, for real estate agents, for probate real estate agents group in that Facebook group. So check there for details coming forward. Our guests are really lucky to have from Anodos, which is trust-help.com. I think he's a founder. He'll tell us his actual job title. Josh Yeager, who is a Esquire, which I guess means an attorney, very well read. He and I have shared some book suggestions. You'll see in the background, I think some of my favorite books along the way. But he actually acts as, well, I'll let him talk about it, but he acts as a kind of alternative in helping estates and families through the probate and trust process. Josh, thanks for joining us today.
Sure. Happy to be here.
And just a quick point of reference, you are located in Santa Barbara or Goleta? Where you?
Yeah, Santa Barbara.
Fantastic. And so your position is you are a fiduciary or a trustee? What's your role in the probate and trust administration process?
Well, I'm a trust and estates attorney. And if you think about the estate administration process, you've got the drafting phase where the attorney meets with mom and dad and they sit down in the big glass office and they write the binder that says what's supposed to happen when mom and dad die. And then mom and or dad die. And it usually is a family member that is named as the successor trustee, typically the eldest daughter or caretaking son or brother from another state. That person is typically unfamiliar with the estate settlement process, right?
That's the way to put it.
Yeah, but they're in charge now. They're the CEO. Yeah. They get the big binder, and it's their job to navigate from point A, mom or dad died, to point Z, checks are being cut, or sub-trusts are being funded. And so that's a kind of a difficult process. And the tradition is that the person that drafted the trust document, the family's estate planning attorney, is the one that is most often looked to help navigate the settlement process. But it usually is the case that the drafting attorney is a contemporary of mom or dad. So they are too busy or retired or dead. They can't really help with the settlement process because they're not in practice anymore in most cases. So I'm the guy that comes along and takes orphaned settlements where the family calls the person with the business card in front of the binder and says, hey, can you help? Dad's dead. What am I supposed to do? I'm the eldest daughter. I got a day job. I'm a architect or a doctor or whatever. I don't have time for this. And that phone just rings off the hook because they're not there anymore. So I'm the guy that comes in and helps settle those estates.
And you contracted through the estate planning attorney, or they just refer you?
No, the estate
point to you, or
estate planning attorney's missing in action.
Right. This is so common. You describe a scenario, and for those who follow this, you think it's unique. I literally was just on a waiting on court a call for a case, and I listened to an air. I've been calling the attorney, and he hasn't been around anymore. Phone calls. This is like if you're in that business every day, and so Josh is feeling kind of this void between the theoretical administration of the trust and the actual practical reality of the administration. And I think the other part that maybe you left out or didn't cover was, which is even if the attorney wanted to do the work, this isn't their area of expertise. You know, they're
Yeah.
maybe legal experts or scholars or knowledgeable and
Well,
write documents.
I'll let you in on a little secret. If there's two things and only two things that trust and estates attorneys do, it is drafting trust documents or amending and restating them, writing the plan,
Right.
and settling the estate. Of those two things, drafting trust documents is by far a much more profitable exercise, by far, because it takes, I don't know, 2 to 3 hours from first intake call with the client to sit down in the meeting to send them the draft document to execute the document. That's probably a 4-hour exercise. And in California right now, the cost for a normal estate plan drafting set is north of $5,000. So that's, $1,200 an hour. Settling estates, mom's got a house and there's an IRA and there's some life insurance and annuities and like the normal, let's call it a $5 million estate settlement with some rental property and an account at Schwab. For me, that's a 20-hour project. And I don't get paid $1,000 an hour to settle estates. So estate settlement is necessarily a less profitable exercise for trust and estates attorneys. So many trust and estates attorneys have so much work from the clients that are demanding drafting support at $5,000 plus for 5 hours of work. We've got 10 million baby boomers in California. Like my colleagues that are drafters are booked out. There's no time in their schedule to do anything other than draft, and they're making the right economic choice of helping their clients memorialize their dispositive intentions. The problem is we're getting a lot of plans written without many professionals focusing on the settlement of those plans, which is actually a much more difficult, time-consuming, expensive, frustrating process because we have a CEO, the eldest son, who's never done this before, who's responsible for it, and the nephews and siblings breathing down his neck, and he's got a day job.
And this issue problem, I see this all the time. It reminds me of, I don't know if you ever followed the Seinfeld show. Reminds me of the episode where he said, taking the when they had the reservation, taking the reservation's easy. It's the keeping the reservation. It's hard.
It's critical.
And I think that to some regard, and I don't want to put down, good estate planning because I've been involved with, bad estate plans and mistakes and litigation and such. So obviously it's important they be done properly and be important to be customized or appropriate for the individuals. But at the same time, none of that matters if you don't administer it properly. Right. And it seems like my father was an old style attorney. He had a partner who did wills and probate, and they had in their office like a closet with a fire safe, and they kept all the documents there. And nowadays it seems like, well, some attorneys do that as a point of value. Mm-hmm. I want to say about half of them say, well, no, I give it to the customer and they're responsible. Well, that's already a prescription for disaster, right? Because the binder's lost, the binder doesn't get signed, the binder, whatever, they didn't put the properties in, all kinds of stuff happened. And I imagine that's when they call you and say, Josh, it's so funny because we got the binder. What do we do? Or we had a binder, or my dad said he had a binder. Where the heck is it? So let's go from the beginning. What do you do when there's an estate? There's an estate, you see things tiled in the estate, but you can't find the actual documents. Where does that leave things?
Oh, if you don't have instructions, you got to go to court. And we know that there's kind of two ways of transferring title from mom and dad, who are now dead, to whoever the heirs are. One is through the probate process. Either they died intestate, there is no will, there is no dispositive instructions, or there is a will. In California, the drafting preference is to avoid probate by doing a revocable living trust. But it's the same duties and responsibilities. You got to do the same stuff. You just don't have an adult in the room, the judge, with a calendar saying, hey, when are you going to get me the valuations? When are you going to get me the record that the debts have been paid off? It's kind of left up to the successor trustee. So if there is no dispositive instructions, that is an intestate succession. And there was one that I was involved in a couple of months ago where the family was sure that there was a trust doc written somewhere. They couldn't find it. All right, well, you can be sure all you want until you can identify the piece of paper that says what mom wanted. It doesn't count.
Right.
There is no paper until you prove that there is a paper. But the state of California decides what the disposition of your estate is if you don't decide. They're like, all right, we have rules around who gets what. So it doesn't really matter. I mean, it matters, but the process is the same, whether there is a trust or a will.
So, and I think the point that people don't appreciate is the challenge of being that trustee. As a former potential successor trustee on a family member, and my aunt died. She had no children, and she had three nieces and nephews, me and my sister and brother. My brother lives in another country. My sister is doesn't work, but she's very sophisticated, very financially well off. And I have a full-time business. And I said, do you mind doing this? Because, I know the work involved. Now I helped her, just my helping her. Now I don't do the work that you do, but I'm just saying, answering questions, filling out paperwork, making a couple of phone calls. It felt like it was like one of the biggest properties I had sold. It was a lot of work. It was a lot of, there's a lot of details in what was a small, fairly modest trust. So
Right.
let's talk about that. The role, I think one of the challenges that I see is when I talk to customers, say you need somebody to do this for you because you don't appreciate how much work it is and how important it is to get things done in a timely manner. When presented with the fee, whether it be $5,000 or $15,000, they almost always say, well, I can do it myself. Well, you can do a lot of things yourself, but what are you going to not do as a result of doing that yourself? So people come to you. I know you're real busy. I know you have to spend a lot of time selling yourself on your service, but maybe just for us as professionals to understand the value you create, how should I evaluate the value of bringing you in versus attempting to talk my client out of doing it on their own? I mean, I just want to sell the house. I want them to be happy. I want them to avoid the pitfall of doing something on their own poorly. How would you coach me or guide me as what I should tell them as a way to say, you're going to need some help here. This is not as easy as you think it is.
Well, I would go the other way and start with the presumption that they're perfectly equipped and have the time and have the intellectual capability and experience to do the work. Because honestly, most of the work of settling an estate or a trust it's pedestrian. It's calling Schwab and yelling at them to get the date of death valuation updated. It's notifying the county that the trustees died and filing the notification. It's filing a deed. It's closing bank accounts. So it's work that you don't have to be an attorney to do. And so I start with the presumption, not everyone on the planet needs my services. And the work honestly it's not for the most part, it's not legal work, right? It's blocking and tackling. It's project management. It's a task list. There might be at the death of grandma with a $5 million estate, there might be 100 things that have to get done. And that list could be worked through by anybody. My thesis is some people don't want to do it. They don't have the time, or they don't have the interest, or they don't have the training to do it. And they say, I just want to be the CEO. I want to punt. And I want to just sign my name. And I want somebody professional to be my glorified secretary to take me through the process. And where that secretary is able to remove things from the list, I want them to. And where they are unable to, I want them to bring it to me and tell me where I'm supposed to sign. So that's my service offering. I'm not trying to convince anyone that they shouldn't settle estates. They were picked for a reason as the successor trustee. They were trusted by the settlor. It's their job to do it. I don't want to dissuade them from that job. I'm just saying, hey, if you need some help, me and my team are here. We're happy to work through the long, frustrating checklist. Like I said, for us, it's probably 20 hours of work to settle the normal, whatever normal is, estate. And the complexity really has little to do with the size of the estate, right? So you can have a $1 million estate that's an absolute nightmare because there's a bunch of accounts and titling is wrong, and you've got mom was a hoarder and the house is thrashed and Uncle Eddie is living in the house, right? It could be a catastrophe, but a small estate. Or you could have an estate with $20 million in it, all in California muni bonds, and that thing's closed in a month and a half. So the size of the estate isn't really the issue. It's the configuration or how much planning or how many how many items on the balance sheet there are that have to be touched.
So, and then your role then as being an attorney gives you the right to kind of settle, act in their place as their attorney.
No,
More,
no,
no?
I'm not acting as the successor trustee. I am a glorified secretary.
Uh-huh.
Okay. So a good glorified secretary will inform their boss, hey, you know what? You're getting up against the illegal guardrails. You have particular duties and responsibilities as a trustee. There are some requirements of you. This isn't just do whatever you think is best.
Got it.
That your beneficiaries that you are serving have the right to sue you if you don't do your job. And my guess is you, as an architect, eldest son, probably don't know what your job is. So I'm in part educating them on what has to be done. That's the creation of the checklist. So what's the first thing? We're not just going to go off and sell the house. That's not the first thing. The first thing is we're going to give notice to the beneficiaries and make sure that we all agree that this trust instrument is the one that we're dealing with, or this will is the one that we're dealing with, and there's not some other one floating around out there.
Right.
Also knowing with what cadence to communicate with the beneficiaries, what's going on. There are some legal things like the notices that requires some modest legal training. You could probably get it from a YouTube video. Retitling property with deeds, dealing with operating agreements for LLCs, interpreting the terms of the trust. What the heck does reasonable compensation mean? So there are some elements of a settlement that require legal training. But honestly, of that list of 100 or 150 things on the checklist, maybe 20 of them are legal in nature.
Got it. Since you're the one that kind of cleans up the mess, so to speak, if things aren't done right, what are one or two of the most common mistakes in estate plans that you see that cause people difficulty that you have to kind of clean up or work around or cause extra stress or problems?
That is an excellent question, which I've been thinking about a lot because I stubbed my toe on a lot of avoidable mistakes. So the first one obviously is mom and dad spent good time and money setting up a trust, and then they failed to fund it. All right, like the house isn't in the trust or the apartment building isn't in the trust, but we know we have a trust. It's like, doggone it. Now we have to settle a trust and we have to probate. A trust is a bucket and it only is effective when something's put in it. So that would be number one. Number two.
We'll stop there for a second, just because we're a little slow here in a sense, we're newer to this comment. So people establish a trust, and it's really critical that the assets get put in the trust. So if it's real estate, that means the title, instead of being held by John and Mary Smith, is in the trust of John and Mary Smith, whoever the name is.
Right.
And the appropriate accounts are also put in the name of the trust. As real estate agents, we have the chance to help our customers by checking public records and making sure that gets done. Yeah. And as a service, and we also, as a service to the attorneys, can offer that. We also, as a service, there's third-party services that will actually make the transfers, because some attorneys will say to the customer, well, here's your deeds, good luck, get these recorded. And and the customer just puts them right in the binder. And they show up in your office with the binder and the deeds that were never recorded. So as real estate agents, this, I think, is our biggest opportunity to create value for our customers as well, and help avoid problems, which is make sure that the assets, and in our case, the real estate assets, get put in the trust. And I also ask a question about the bank. So that's the number one problem that you see. What would you say is there another number one or two that jump out as mistakes in estate plans?
Yeah, and I wouldn't, though the house is often the most valuable asset of the estate. That's the glaring one. But there's a whole bunch of examples where there are other assets that should have been put in the trust that weren't. Like one I'm working on now. Dad consistently went out and invested 50 grand in every local bank's CD offering. So he had a bunch of CDs. Each one of those CDs was $50,000, but cumulatively they were over 250. So if you have assets of more than 185 grand in California, cumulative assets that are not in the trust, you add up all of Dad's CDs, the expedited probate settlement process with an affidavit isn't available to you. You got to be below the 185. So the older generation that kind of keep a lot of cash around and kind of think that diversification means having a whole bunch of different checking accounts. Everyone looks around and says, oh, he's only got 25 grand in this account. This isn't a probate risk, but it's the cumulative value of all the stuff that wasn't put into the plan. There's a lot of, I've noticed, in a typical trust instruction, at the death of the first spouse, there will be the funding of the bypass trust. There, the deceased spouse's community property and separate property go into bypass. Some trusts say the bypass trust shall be funded. Other trusts say the surviving spouse has the discretion of whether to fund that or not. And the typical drafting language in the 90s and early 2000s was mandatory funding because the lifetime exemption amount was lower. We were working with $600,000 at that time. Now, with an exemption amount of 13 million, the funding of the bypass trust is not as important. And there are a lot of instances where the client says, look, the primary asset is a house in La Jolla worth $3 million. Do we really have to take half of the house and fund it to the bypass trust because dad wrote the estate plan in 2001 and that was the drafting approach back then? Like, how are we going to do that? We're going to take and there's plenty of examples of this where dad's half is in the bypass, mom's half is in the survivors. The property tax, mom's got to pay rent to the bypass trust because it's got a unique EIN, just enough to pay for the property tax and half of the insurance. It's like, this is nuts. We could have solved this problem if we had just amended the trust from saying shall to may. That's like the easiest trust amendment that there ever was. Section 7, paragraph 3, substitute the word may for shall. Oh, great. Now we don't have to get in this whole stupid mess. So that's kind of a legal issue. Ones that I deal with a lot are the non-legal issues, the fights over the 64 Mustang. Dad never gave any instructions on personal property. And there's 3 boys and they all love the 64 Mustang. Or dad died and there's a whole collection of gold coins and nobody knows, are these coins valuable because of their numismatic value or are they valuable because they're gold coins? And nobody knows, like, how are you supposed to sell $500,000 of gold coins? Or the family's walking around with a safety deposit box key, but they don't know which bank in the town that safety deposit box key goes to, right? All of those are examples of things that it's not the attorney's job to solve those problems.
Right.
It's not the financial planner's job to solve the problem. It's the family's job to think about, hey, what would be helpful for the successor trustee? What kind of instructions or rehearsal could we do to make this administration good? Let's pull the deed and make sure the house is in there. Let's check the beneficiary forms. Let's do an estate tax pro forma to see if there's going to be any estate tax, which there almost never is, but everyone's freaked out about estate tax. Let's describe what is supposed to be done with mom's jewelry. Let's create a list of the key contacts of where the hell we bought the gold coins from, because let's go back to that guy to sell them. So there's like a process of probably, I think my list is probably 35 items at this point of things that I wish the family had engaged with mom and dad before they died and just went through the list and freaking solved it. Now, it doesn't apply to us. We don't have an apartment building. Oh, does apply to us. Mom has a huge Yadro collection. What the hell are we supposed to do with those Yadros? Right? And if we ask those questions while the settlors are still alive, then we can make the administration twice as fast. For sure, twice as fast. So it's the ounce of prevention is worth a pound of cure thing. If we just think about what's going to tie this up at the back end and like, let's solve it ahead of time.
And the blood on those disagreements, my family was involved. You mentioned Yadros with they called them lusters. My mother's mother passed when she was quite young, and they were poor. And the only thing they had were these, they called them lusters. They're like these crystal kind of decorative pieces you put on a formal dining room table.
Yeah.
And my mother and my aunt, her sister, and her 2 brothers fought over these lusters.
Yes.
When I was a kid, I kept hearing about them. And until you give me the lust, my grandfather got remarried. Until you give me the lusters, we won't have a relationship. And I remember my grandfather moved from Philadelphia to California when I was in high school, and he brought the lusters. I'm thinking, like, this is like I don't know what I think, like the what's the Ark of the Covenant. Like, this is going to change the world.
Right.
And they passed the luster, and for years the blood over it was irrelevant. And whenever it came to it, and had they just made a little list and said, okay, they're going to go to the oldest daughter or the youngest son or whatever, it would have avoided all that. And you're right.
So that happens in probably half of the families. The estate settlement is delayed because of lusters.
Yeah.
And the cost is increased.
Yes.
because of Yadros, or
Yes.
because the estate trust, the document says the successor trustee, the eldest son, shall be paid a reasonable amount.
Yeah.
What's reasonable? Like we get stuck for 6 months on what's reasonable, or what are we going to do with the coin collection, or can we cut the 64 Mustang in half because the two brothers are fighting? So many of the delays are not about legal documents. They're about humans' broken hearts and incomplete promises and non-clear instructions from mom and dad in their last days. And it's like, those are avoidable.
Yeah.
The problem is there isn't any professional discipline that does that. Attorneys, that's not attorney's job. They're busy making $6,000 per trust document.
And I think also, because families don't grieve while they're, in an appropriate time period, they use this process to deal
Right.
with the emotions, and they just become those emotions become raw and difficult. Let me just get real quick to just do some quick housekeeping kind of update on where we are. Again, this is Probate Weekly. We do this every Thursday morning, 9 a.m. live in a Zoom call. If you want to join in, go to probateweekly.com, put your email address in. We'll send you reminders. You can jump in on the Zoom call. Those are in the call now live. Feel free to ask questions. We got some good comments about the Mustang. We have a little disagreement with you, unfortunately, on the best year of a Mustang, but that's not
No,
quite
69. No, boo, 64.
I agree. I 64, 65, maybe.
Yeah.
69 to me is just
Yeah.
past its prime. But anyhow, probateweekly.com, where you sign up, you can scroll down, you can see us in other formats, audio formats and such, past episodes on youtube.com. Continue the conversation on Facebook at our Facebook group, probateweekly.com. You do have to register your email address there, but we encourage you to post your probate and trust-related content there to get more views, to share information, share ideas together. Also, we get referrals there for attorneys and for real estate agents across the country. We have about 4,000 members. Love to have you participate there. Our guest today is Anodos, which is really a service that helps trustees and executors when they're in the process. And our guest specifically today is Josh Yeager, who is an attorney, but his primary function here is not necessarily as an attorney. That's more helping his background, but is helping trusts and executors get the difficult work done along the way of the process. So again, if you're on the line, love to have you participate by raise your hand, ask questions in the chat box. We'll do our best. Unless you have more comments on the Mustang, I'm just sorry. 69 Mustang it's not worthy of discussion.
69 is a great Mustang. I shouldn't bag it.
Well,
But
it's great compared to the cars of 69. It's just
right,
not. It's just
right,
not iconic.
right.
It's just not. Okay. So let's talk a bit about, if you don't mind sharing, obviously you have I think a fairly unique niche in that, I mean, I deal with a lot of probate cases, and it seems that either the attorneys do it on their own, or the petitioner or executor or trustee does it on their own. And the only time I normally see a third party in the middle is when there's a dispute and they're kind of forced to accept somebody else, or that somebody else was named in the trust or the will to fill it out. And I say this with disappointment that I've so often recommended my customers to say, this is going to be a tough process for you, and you're really going to perhaps spend more money than you're going to save with time, effort, maybe legal fees, conflicts, and such. And so talk a little bit about how you've built your business. Like because this isn't, I don't think, a standard function. This is something that because the value you've created and people, I guess, recognize it, and you've built a reputation, come to you with a request for this. How have you built this business? Or is this something that you did see and you've competed for it along the way?
Well, there's not a lot of trust and estates attorneys that want to do the settlements. Like I said, it's time consuming. It is lower margin business than drafting. And if you are faced with two alternatives, one that pays you $1,200 an hour, because it takes 4 hours to draft a trust doc, or one that pays you $250 an hour, which are you going to choose? So my colleagues are making the rational choice. There aren't very many trust and estates attorneys that specialize in estate settlement. My thesis is, look, there's 10 million baby boomers in California that are going to die in the next 20 years. There's $15 trillion of assets. And there are fewer and fewer trust and estates attorneys every year because my kids
Yes.
don't want to go work at Google and Amazon. They don't want to work
Yes.
as a trust and estates attorney. So
Yes.
there's a catastrophe coming.
Yes.
And the common drafting methodology is to name a family member that has never settled a trust before, that doesn't know what they're doing, that it is a burden for them to settle the estate. And my thesis is, look, this is where the market's going. There is need here. I'll figure it out. I'll figure out how to deliver excellent services twice as fast at half the cost with lower risk to the successor trustee. And I believe that the new model of service delivery is that I can deliver this service to people from Eureka to San Diego, that we don't have to have the geographic proximity that we once did in the white gloved estate planning practice, where we're dealing with people in our own county and the judges from our own county.
Kind of a related industry, similar, different, fiduciary.
Yeah.
It amazes me how busy, I'm pretty good at, I reach out to you and get people to interview and promote them. And I hope I create value, along the way for you and the people I talk to. Fiduciary is one of those industries where it's been very hard to even get into them because they're so busy. They're older. They're not as common with technology. And it seems like there's not nearly enough for the business coming in. You talk about the increased assets that are going to be transferred in the next few years. That similarly is another piece of that, or maybe it's the next step over from where you are or related to what you're doing. It's amazing to me how that industry is so underpopulated for the needs. And I'm sure it bleeds over then to your business, right? Because the fiduciary might be a way that an attorney might have in the past recommended somebody. What's the difference between what you do in a fiduciary and how should we think about it?
California is one of the first states to recognize that there's this job. I call it the eldest son for hire, where the family looks around and says, there is no one qualified that I trust to settle my estate. It's too hard. It's too complex. These are usually more wealthy families, say $5 million net worth and above, but that's not exclusively the case. So California recognized a profession called the Certified Licensed Professional Fiduciary. You can go take a test, become that. You are overseen by the state in the same way that other professions are overseen by the state, like attorneys and CPAs, et cetera. The trick with, and right now that there are, I think, 1,200 licensees, maybe 1,300 licensees at this point, that can hold their hand up and say, I am a candidate to be your eldest son and to settle your estate. The way that those people get business is they go and tell the drafting attorneys, the trust and estates attorneys, hey, I'm available. I'm an eldest son for hire in your community. Drafting attorney the next day is sitting down with the client. Client said, drafting attorney says, who do you want to settle your estate? Client says, I don't know. I don't have anyone. My son lives in New York and he's an actor and he's not qualified to do this, or there's drug problems, blah, blah, whatever the answer is. And the attorney says, I just met with Kevin. Kevin's a great guy. He's 45 years old. He's a CPA. He's acting as a licensed certified professional fiduciary. Do you want me to write him in as the successor trustee when you die? Yes, by all means, please write Kevin in. So Kevin is now written in. Once mom and dad die, there is no opportunity to bring that fiduciary in because it's the settlor's decision who is going to serve as the successor to them. So the marketing strategy for certified licensed professional fiduciaries is either to be assigned by judges by sitting in courtrooms and probates that need some personal representatives named, or to go to the trust and estates attorneys. But I know these 1,200 people. They're my friends and they're my clients in many cases. They are up to their eyeballs. Like if you get your license, probably in 2 or 3 years, you are absolutely cooked. And you're asking the question, how do I bring in partners? And how do I have a practice succession? And how do I continue to serve my clients with the same vigor that I did it at the beginning? It just goes to the point. There's a lot of freaking work out there. There's a lot of work. And it doesn't matter whether you're probating estates or whether you're drafting documents or whether you're serving as a professional fiduciary or if you're remodeling bathrooms with the money that the inheritors get. Like my buddies who are house builders are saying that they are having an explosion of inheritors remodeling their bathrooms because they just got $300,000 from grandpa's estate. Great. So remodeling bathrooms is now part of the gray wave and a beneficiary of that. Same with selling houses, right? All of the houses are going to turn over.
There is no industry that I've seen, and I see a lot of industries. The nature of a real estate agent, we see a lot of different things. I'm, kind of, low quality, depth, but wide variety of people. There's no industry I've seen that it is literally, like you say, overwhelmed with work like fiduciaries. The
Oh, no.
person, the
And
person
it's
that
not,
introduced me originally was a banker, but who reminded me to talk to you was a friend of ours who's a fiduciary, and he got licensed, and within a few months has a huge estate that we're working on together. So
oh
really a
yeah,
full-time job.
yeah. And that's true of all of them. That's true of all of them. There aren't enough. But that's like a teeny subset. So let's say that all of those fiduciaries, let's just do the math. We've got 1,200 licensed fiduciaries in the state right now. And the most that one licensed fiduciary can handle that I've ever heard of active cases is 50. Okay. So we've got 1,200 times 50. If every single certified licensed fiduciary in the state had 50 estates, that would take 60,000 out of the market.
Right.
I told you there's 10 million baby boomers that are going to die in the next 20 years.
Yeah.
Like that's not even a dent in it. We've got 500,000 estates to settle per year and increasing.
Yeah. And it's getting more complicated, more complex, more as a general.
I don't know if it is like transferring title on the house or dealing with Schwab or closing a business. Like, I don't know how that's different now than it was. I think some of the technology makes it easier. Like how fast can we do a deed now versus 20 years ago?
Way faster.
Way faster.
For sure.
How fast can we read the estate document with AI now than 20 years ago? Way faster. How fast can we change title on Schwab or Fidelity accounts or fill out applications?
Depends. That one depends on who some people get tripped and it's a nightmare, and others it gets done very quickly. So I would say service level, at least what I see all the time now is service levels across the board are worse. Technology's gotten better. And so as long as you can avoid the service requirement of a human being, everything's a lot easier. Right. But once you get a person at Schwab who opens your file or the bank.
Yeah. Well, you know why? As soon as any professional in the financial services industry gets notice that their client's dead, everything's on lockdown. And the account gets accelerated to the estate settlement team. The estate settlement team is populated by who? Bunch of 25-year-olds that recently got out of college that have a degree in art history, right? And that's not to bag on them. The problem is the volume is incessant and growing. So those firms cannot staff their estate settlement teams fast enough because my kids don't want to work at Schwab's estate settlement team.
Yes. So I would say, like, for example, talking to a lender on a reverse mortgage to avoid foreclosure when we're listing the property. That used to be a lot easier because companies took pride in their service. Now they've, with technology, created a new company that's anonymous that they can give lousy service to, and it doesn't reflect back onto the lender. And so it's impossible almost to talk them out, and you have to go to court to avoid foreclosure, right? So that's an example of where it's harder, but it's easier, but it's harder at the same time. And so anybody that's called who's a real estate agent, I think it's a great line to get into, not just to get the license and be a fiduciary, but to get the training and do it properly. There's professional organizations and they have training and classes. And I think you probably need some accounting background. You need some legal training, not necessarily as an attorney, but regarding the rules. I got asked by one of my vendors to be a fiduciary on an estate that primarily is just selling a house. And they said, you can handle this for us. And I got a fee, and in California you can do 2 without having to have a license. And I did good on one, and I do another one. I said, yeah, sure. I'm trying to help them out. Next thing I know, I'm signing all kinds of papers. I have to read stuff up, and all of a sudden I realized and then things didn't go as smoothly as you thought. The court date got extended for 6 months, and next thing I'm in your job, but trying to do it on my own, one at a time. But I do think there's a great opportunity for those of us who are of a mind to do the administrative work to get licensed in this field, because there are people who are going to need this service. It's like that's the golden tidal wave. It's not real estate agents that we're going to see that many more houses sell. I don't think it's investment companies are going to see that much more in assets, though they're going to transfer. It's the administrative work in the middle and fiduciaries and trustee work that I think is just going to explode, and there's nobody there to help customers with that at all.
Yeah, we got problems. My kids don't want to be in the trust and estates business, and it's a faster growing, more lucrative business than working for Google.
I'd say it's more real and more personal. I guess that's why I'm in real estate. I'm not at Google, is because I was in technology, to be honest, right out of college. And I left it because I wanted to deal with human beings. I wanted to help real people. I loved it when people said thank you, or I delivered a check at the close of escrow in those days.
Right.
So we have a question here. Sonia Santos asked, as a real estate agent, is there a checklist to offer clients to help them? And do they talk to you before or during the planning process? So I think the answer there, I know the second question, I think the answer is no, you're more after it's been drafted. But I guess maybe the better answer is, my guess is you work with both good estate planning drafters and bad. You work with the good ones by choice, the bad ones by accident. Are you a source to refer people to estate planning services?
Yeah, well, the current, let's talk about estate drafting.
Mm-hmm.
So there are two solutions right now. My colleagues in the white glove trust and estates firms with Class A buildings and big boardrooms and lots of staff and $6,000 per package. The other approach is the DIY approach. Call Wills and Trust, call LegalZoom, call Rocket Lawyer, and fill it out yourself. Those are the two solutions right now. So Anodos has created a new solution, which is kind of do it really fast for the non-taxable estates at half the price of what my colleagues will charge you. So I say, if you have a taxable estate, whatever the exemption amount is right now, 13 million bucks, you should hire my buddies and you should pay their $7,000 fee, because the planning that they will do takes time and has a massive financial impact. So doing estate freezes or discounted gifts or any number of the strategies. Like those are
avoiding
big
taxes on $1 million more than pays for the legal fees.
Totally. So rich people should use them. The evidence is that modestly rich people, let's say $10 million and less, are not comfortable doing it on LegalZoom. They're not comfortable changing their deeds. They're not comfortable knowing, well, how should my IRA beneficiaries be set up? Like they are frustrated with could be exorbitant fees. It's really, I think, a more robust service offering than they need that the white glove colleagues provide, and do it yourself, mostly because they're not comfortable with do it yourself. DIY is better for the 40 years old and under set rather than the folks that prefer to communicate on Facebook, right? So Anodos will do really fast, really clear, efficient trust and estates documents for 3,000 bucks. We get them done in 72 hours.
Wow.
Anywhere in the state. And I picked 3,000 bucks because that's half of what my buddy charges down the street. But I'm not going to put as much time in there. I'm not going to have a nice binder. I'm not going to wear a suit. I'm not going to have a Class A office. I'm not going to become a trust and estates professor and educate the client on all the permutations of possible estate tax avoidance or minimization strategies, because they don't need that. And the truth is 95% of the people out there don't need that. They just need a living trust, a couple of pour over wills, durable power of attorney, and healthcare directives. They need that package. You know how long it takes me to make that package? About an hour.
Right.
So it's like, do the interview, get the package, have my colleague read it, send the flipping thing out for execution. We don't need to have the high, robust level of service that my colleagues provide. And I appreciate that not everyone is going to be comfortable with the DIY approach of doing it online. Now, by the way, those do-it-yourself documents online are killer. I've read all the documents. I've received them all. They are as good, and in some cases better drafted than my colleagues' documents. So the issue is the implementation. You can get the great documents for 500 bucks or 1,000 bucks from LegalZoom or Trust and Wills. The trick is implementing. Do you know how to change the deed on the house?
Right.
Do you know how to call Schwab and decide whether I'm going to do a transfer on death or I'm going to retitle this? Do you know how the beneficiary forms should be completed for the IRAs? And most people say, look, I can get the documents, but it's the implementation of the plan that's the tricky part.
Correct. Like everything in life.
Yeah,
there's
like
plans,
everything in life.
There's the execution, and the execution is really what makes the distinction.
Yeah. So the three things that we do at Anodos: we write documents. really fast, really cheap. If you're rich, don't call us. Call my buddies. The second thing we do is we audit estates before dad dies. It's usually when somebody's got a bad diagnosis. And it's like, this estate is going to be settled in the next 6 to 12 months. Somebody better look at dad's documents because nobody's looked at them for 20 years. And we check full title on the houses, look at beneficiary forms, read the trust document, make amendments if we need to, get information from dad on where the hell, or what are we supposed to do with the coin collection or the yadros, right? So we go through the things that we know are going to trip up the estate. That's $3,000 also. And then the last is the settlement of the estate. Dad is now dead, and it falls on the eldest daughter to get this thing done. And our fee for that is $10,000 or $5,000 per million. So most of the estates we're settling are $3 to $5 million. So it's a 0.5% basically. And I'm not saying that everyone needs to hire me because it's actually not that complicated to change title or go through probate or deal with Schwab or figure out the 69 Mustang, right? It's not that hard.
Right.
But if it's worth 10 grand to not do it because the successor trustee's got a day job, fine, hire us. We'll get it done twice as fast as you will for sure, because we know what we're doing.
So 2 questions on your drafting process. One is, do you also fund the plan? Do you do the deed and get it recorded for the real estate property?
Yeah, it's no good. It's no good to have a plan unless stuff's put into it.
And for those listening, in your own area, maybe in a different state, and you want to work with estate planners, it's a critical question to ask, because to me, it's not just that it avoids the customer's problem, it shows the commitment of the attorney to solve the customer's problem, right? We all want to get paid, but we should be wanting to get paid to solve our customer's problem or prevent one. And to me, writing the estate plan and not transferring the property into the trust really is not a complete solution. Second is, and this one's a little more controversial, do you keep copies of the documents? Do you keep a copy and give the originals to the customer? What happens? Do you do anything to help prevent the customer who's going to lose the book or the binder or the documents? Do you keep an electronic copy, a certified copy of it?
Well, the modern approach is to not keep documents.
Right.
And the reason that is the modern approach is because Adobe Acrobat exists, and we can have electronic copies that are pristine and that we can prove are the original copies. So if that's the case, I can write a trust doc for myself or for you, sign it, execute it, copy it, and burn the binder. And the electronic copy is just as good. So what I do for clients, and remember, if I'm doing these things for $3,000, I'm thinking, how can I cut costs out of this? Building that freaking binder is one way of cutting costs on it.
Yes.
So I say, look, here's your trust doc. Everything's executed. It's on a thumb drive. Give it to your kids, put it in your wallet. I've got a copy on my server. It's backed up. We're not going to have a problem knowing what your trust doc says, because we actually don't need the physical binder anymore. We just need to prove that our electronic copy is a legitimate version of it with an online electronic vault or whatever we do.
Okay, let's pick up a couple questions here as we kind of come to the end. Links where I can get fiduciary certification. Again, Josh is not. So Augustine, if you send me an email, I'll send you a link to I actually started the process myself and decided it was just a little more work than I wanted to get involved with to get licensed, but I'd be glad to give you some information I have on both the certification and I think some good.
Yeah, Augustine, what state's Augustine in?
I imagine California. Otherwise, there's no licensing, I don't think, for fiduciary other than California.
Yeah, just type in PFAC is Professional Fiduciary Association in California. That's the California website. And then you can do a search on whatever county you're in or city and the people with the license in your area that will pop up.
So PFCA?
Yeah. I'll drop it. I'll drop it in the chat right here.
PFAC.
Thank you, sir.
PFAC.
Thanks, Josh. And then
yeah, sure.
And then Ann Bollinger asked, how can I find similar service in my area? So Ann, I'm not sure what your area is. What state are you in? Obviously, it varies by area. And that's a good way to ask the question, Josh. What areas do you service?
California.
Okay, so
I'm a California attorney. I want to break the old model of my buddies in the white glove service profession serve clients in Santa Barbara County.
Right.
But why do we have to have that constraint? Like, I know how to draft a trust doc for someone in Eureka. Right. I know how to settle an estate or go through probate in San Diego.
Right.
So why do we have to have buildings at all? Why do we have to have conference rooms? All of those things are overhead that add to the cost and barriers to accessibility of good legal advice.
Well, you're talking to a guy who's associated with the largest real estate company in America, and we're all virtual. We don't have a corporate
Right.
headquarters. We have no regional headquarters. We have
Right.
88,000 agents, and none of us have an office other than when we pay for our own. For those who need one, I have a home office, but there are agents
Right.
who decide. But that's like music to my ears. And
so Ann says she's in Reno.
yeah,
So I can't help anyone in Reno draft the docs. You need a Nevada attorney to cite Nevada statutes when drafting the doc.
yeah.
But I can help clients, and I do help clients in all states with the audits of their estate. Where's the key to the safety deposit box? What do we do with the Yadros? What about the gold coins? What about the 69 Mustang? Do we need to amend the trust doc to say may instead of shall? Like that process is agnostic as to state statute because it's process. We all states have the same probate code. It's just we've tweaked the citations, right? The California probate code is the same as the Nevada probate code, but I'm just not licensed to work in Nevada. And estate settlements, the same thing. I can do estate settlements in any state.
When I've interviewed several probate litigation specialists, attorneys who all they do is litigate. They don't draft documents, they don't administer estates, trusts, or probate. They ask them this question: true or false, 90% of the time, you're better off with any document than none, right? Whether it be trust and will or whatever online service, LegalZoom, that any standard commercial document is better than nothing, 90% chance. Every litigator I've ever talked to has said yes. Would you agree with that?
Yeah.
Because you can fix a lot of the problems, but you can't fix it if you don't have a trust.
Yeah, or a will, right? And I'll say it differently, an expression. The state will answer the question for you. What is to be done with your assets? Right. The state will answer the question unless you do.
Right.
And I'm telling you, the words that are written in the do-it-yourself documents are really, really good. My colleagues dispute that, right? But they have a reason to dispute it, right?
Yes, they do.
Because they're charging $7,000 for the same thing that's $500. So I tell clients when they call me, look, if you're okay with a DIY, you're going to save a lot more money. You're going to save $2,500 if you don't hire me. And you just go to Trust and Wills. Their site is awesome. The process is awesome. But some people that have, pick a number, $1 million, $2 million, $3 million, say, look, I'd rather just pay an attorney to do this. And I know that I could do it on my own. And clearly there's an age and comfort with technology thing where my kids' age people that have wealth, they're fine doing it with LegalZoom. And the documents are great.
The statistic you'll never get is what percentage of people pay for and start on LegalZoom or Trust and Will and don't complete the document.
I've heard it's a really scary high number.
They'll never tell you that number because that's the problem. And I think that one of the things that the unstated part, and I've interviewed a lot of drafting attorneys who charge $3,000 to $5,000 or $5,000, $7,000. Part of the value, I think, is the relationship that inspires the customer to finish the job. And you say, why are we paying an attorney to do that? I don't know that you need to. I don't know that you should. But I do know in reality, if the attorney follows up or their staff follows up and that gets the job done and gets them over the line to get the paper completed, executed, and titled, then it's probably worth it. And but again, get something done. And as real estate agents, and there's one thing I'm really on a soapbox to push, is we see whether customers have a plan. We sell them the house. It's a public record. They're proclaiming to the world, either I have a trust, and here's the name of it, or I don't have a trust, and I need one. And I think as real estate agents, this is the area that we should take the time to learn. We should also take the time to go out and meet the best professionals in the field so we can introduce them to them. And I'm really proud to have met Josh along the way so that I can introduce him to you on this call, as well as to my clients as well. So Josh, I just want to tell you, coming up to the end of the hour, and I know you've been really generous with your time in the past and this time as well. I just want to thank you so much for taking time to educate us on the importance of having, in many cases, assistance for trustees and executors of estates. And I'm going to put your contact information in the description down below. But thank you so much for taking time with us today.
Sure. Happy to do it. I had fun.
And just as a reminder for the rest of us, this is Probate Weekly. We do this every Thursday at 9 a.m. Pacific live. If you want to join us, all you need to do is go to probateweekly.com, and there you can just fill in your email address, and you'll get notification to come in the Zoom call live as well. If you hit the register button, scroll down, and you can get us on the various audio formats, Spotify and Apple Podcasts and those things, and go to YouTube, which is our primary channel, and see our past episodes as well as other related probate content. We continue the conversation on Facebook on our Probate Weekly group. We have about 4,000 professionals across the country. So if you're looking for referrals for attorneys or realtors in other states, also post your probate and trust related content there to get additional social media love. We'd love to have you guys participate there. Again, just want to thank our guest today. Anodos is a company that helps trusts and executors saving time, reduce risk, and fulfill their duties. And our guest specifically today was Josh Yeager, who's an attorney, but really works in this field of helping trust executors, working with attorneys who do draft documents, but need somebody to help their customers over the finish line. Really appreciate him being on here, and as well appreciate all of you guys being on the call as well. I'm at Bill Gross Probate, or BillGrossProbate.com is my website. Reach out and help you anyway. Thank you again, everybody, and we'll see you soon. And Josh, thanks again.
Yep. See ya.